Hello everyone, this is Dr. Patrick Azanza, your HR coach. Our topic for today is how to deal with problem employees. At the onset, I would always tell HR professionals or HR managers that our recruitment standards, our recruitment policies should be able to allow us to avoid hiring the wrong people. So when this happens, my recommendation is to review our recruitment policies, our recruitment standards, so that we will be able to avoid facing the same problem in the future. Because I would always think that prevention is always better than a cure. Every person has the ability to discern what is good and what is bad. And depending on your social background, you would be bringing into the company whatever values and attitude that you have developed as you were growing up or as you were being exposed to different social realities. And essentially, your work ethics will define the kind of service and your performance at the workplace. Companies normally adopt an employee's code of conduct, which is designed to be followed and strictly guide the employees on how they should conduct their affairs within the company. And yet, even with the certain rules that we have defined or we have told the employees as they were onboarding, still there are employees who would defy the rules, who would behave differently, who would fail to deliver and meet the company performance standards. I could think of 3 types of people who would give headaches to our HR managers and HR professionals. The first one are the so-called problem employees. They come to the workplace or the company with lack of skills or lack of experience, or maybe with certain negative attitude or behavior. But basically, while I call them problem employees, I would not dismiss them as someone who would not be corrected. Certain interventions can be made, such as trainings can be provided for those who lack the skills and experience. And this would allow them to cope with the requirements of the company. And those with some attitude problems might still be corrected through a values reorientation program. The second type of people are the ones I call difficult employees. These are the ones who cannot easily be corrected. You've provided them training, you've provided certain intervention, you've allowed them to attend a values reorientation program, and yet you do not see any change. And basically, some would call them hard-headed. And these are the difficult type of people. They could not easily be given instructions, and no matter how you try, they seem to be difficult to understand. They seem to be unable to cope. Third type of people are the ones I call toxic employees, and they are the ones we do not want to have within our company, because they do not just fail to observe company standards, they do not just fail to fit into our company culture, they do not just fail to have good relationships with other people. Worst is that they even permeate to the rest of our workers. They influence others, they gather negativity in the workplace. And so they are called toxic employees. Failure to conduct themselves properly within the workplace is not uncommon, and that is why basically we have the employees' code of conduct to allow them to be guided in how they should behave within the workplace. Let me clarify that unacceptable behavior at work does not just refer to actions that fail to meet company standards. This could also refer to inaction made by the employees. The ones that the HR professionals or HR managers are very much concerned about are the action or inaction on the part of the employees that brings risk to the business or challenges in terms of safety and security of their co-workers and management. So essentially, there are 5 reasons why we would have problem employees at work. Number 1 is their lack of skills. Number 2 is their lack of experience. Number 3 is their inability to fit into the culture of the company. Number 4 is their personal concerns. They might have problems at home or at a personal level that affects their performance at work. And number 5 is behavioral problem or attitudinal concerns. This is not an exhaustive list, but these are the things that I could think of as the probable root causes of having problem employees at work. And so every day, HR practitioners, HR managers, or professionals are faced with different types of problem employees. We have the laggards, the lazy ones, we have the rumor mongers, the gossipers, we have the free riders, we have those who are unable to work with teams, we have employees who are wasteful, and employees who are not safety conscious. We also have those who are the know-all type of personalities, those with star complex. And we have the pilferers, we have the bully, the troublemakers, those who play victims. These are the different examples of problem employees who bring headache to HR professionals and management. And we just have to deal with them squarely. So in this specific HR session, I will share with you 10 actions or strategies on how to deal with problem employees. Number 1 is have a very good orientation or onboarding program. If you are able to orient them on their first day or even before they report to work about the standards, the rules of the company, then basically you have solved at least 50% of the problem. Because most of the problems that arise with employees is that things that were not told them, or they fail to understand the rules because they were not informed about the specific rules or the implications of the rules, how important they are in meeting company objectives or protecting the interest of the companies and the welfare of their co-employees. But these are things that we can address during the orientation or onboarding programs. So if we provide them with a copy, whether digital copy or hard copy, that they need to acknowledge the code of conduct of the employees and the standard operating procedures in their place of assignment, then we have essentially addressed 50% of the problem. Another important thing that we need to inform our employees upon hiring are the company's core values, the vision and the mission of the company. These are very important inputs to the employee so that he or she will be able to properly adjust or adapt to the company culture. Number 2 is humanize the rules. The sanctions corresponding to the violations should be graduated, and it depends on the gravity of the offense. And also, the way to humanize the rules is that the requirement should not be something that is impossible to do, something that even top management will not be able to comply. These rules should be based on certain realities and certain capabilities and should allow the employees to comply. Otherwise, if they are impossible to meet, then there's no use having these rules. The third one is putting a grievance machinery in place. There should be a mechanism by which employees could air their problems or concerns within the company. Otherwise, if they have no way of venting, there's no way of allowing them to express their side, then this will boil up inside them, and chances are it's like a social volcano that will one day erupt. The fourth one is act immediately. If there is a certain violation at work of company rules, then you should be able to immediately address it. Do not think that it will resolve by itself. You have to do your part and implement the rules and the sanctions so that people would know that you're serious about implementing the company rules. The fifth is talk to the person. You should be able to listen to the side of the other party and talk to the person concerned so that you will be able to understand his side. Now, in talking to the person, be very specific. Identify the problem and share with the person how this action or inaction on his part or her part affects the business, affects the other workers in the company. Be very specific so that the person will know exactly what the problem is all about. Identify which behavior, which inaction or action violates the company rules, and inform the person the corresponding sanction that he or she may be facing if he continues or she continues doing the same. It's like a coaching exercise. But do not forget, make sure that you have a discussion log. Let the person acknowledge that such talk has occurred and there was a discussion and you have agreed to a certain corrective action on his part or her part. And then let the person sign or acknowledge the discussion log. Give them a copy so that they will be guided as to what were the resolutions between the two of you and what expectations, what corrective behavior he or she must do in the next coming days. Number 6, be clear to everyone that violators will be subjected to the company rules and sanctions. There will be no sacred cows. Apply the rules evenly so that they would see that whether it is at the level of management, mid-level of management, or at the lowest ranks, the company rules shall apply. Number 7 is a bit technical. Observe due process. And when we say that, HR practitioners, HR managers, and professionals have to be aware of the Department of Labor and Employment rules as well as the standards imposed by the Labor Code on due process. We cannot just sanction or remove an employee without observing due process. And when we talk about this concerns about the twin notice rule or the two notice rule that our employees should be accorded. The first one is the notice of investigation, wherein he will be informed or she will be informed of the specific charges, the details of the ones being complained about him or her, and it should accord him an opportunity to be heard. A conference to hear his or her side must be scheduled and conducted. And of course, the second notice is the information about the decision on his or her case. So due process is all about giving the person an opportunity to explain his side. It's about listening to his side. When we issue a notice to explain to a person, take note that we should allow him to have at least 5 days, some companies would say 5 working days, to be able to provide an explanation, ample time to explain his or her side. And what should HR managers or HR professionals do if the concerned employee does not want to accept the notice? Well, you could find a witness and let that witness sign that the concerned employee refused to accept the notice, and then you can mail it to the last known address of the employee, the concerned employee. Send it through registered mail, and that should be enough notice to the person who refuses to accept the notice to explain. Number 8 is decide based on the complaint that was issued to the employee. It is very often that HR managers or professionals fail to consider that they can only decide on the case of the employee based on what was complained about. Part of the due process is due notice. And if the employee was not informed about a specific charge, then he could not be held accountable or she could not be held accountable based on something that he or she was not allowed to explain. We should always remember that an employee is innocent until proven guilty. And so we need to have a quantum of evidence so that we could say that the employee is really responsible or can be held liable for such charge. Burden of proof rests upon the one who alleges. So evidence and witnesses, documents to prove what is being charged have to be presented to the investigation committee. But what if the employee concerned does not want to appear during the hearing or conference? Then you could issue a notice that continued failure to appear before the hearing committee or investigation committee would be considered as a waiver of his or her right to be heard. And in such case, the investigation committee will be forced to decide based on what is made available to them. But this does not also necessarily mean that when the investigation committee decides ex parte or in the absence of the person charged, then automatically he would be or she would be guilty. No, it is still dependent on the available evidence and statements of the witnesses that the investigation committee will find the person liable or not liable on the charge based on how they appreciate the quantum of evidence. Take note that in a labor case, the quantum of evidence necessary is substantial evidence. And when we talk of substantial evidence, it is such amount of relevant evidence which a reasonable mind might accept as a justifiable reason to arrive at a certain conclusion. It is a relevant evidence adequate enough to justify a conclusion. Take note that it is a different quantum of evidence when the case involves criminal cases, wherein the person has to be proven beyond reasonable doubt, or in civil cases which relies on the preponderance of evidence as a basis for holding the person accountable. Preponderance of evidence refers to the probability of truth or the greater weight of evidence. And this is not the requirement for labor cases, which only require substantial evidence. Number 9 is apply the rules and sanctions evenly and fairly. As they say, what is sauce for the gander should also be sauce for the goose. Take note that as you appreciate the case, there will be certain circumstances that could aggravate or lessen the sanctions given to employees. There might be some justifying circumstances such as obedience to his superior, self-defense, or state of necessity. And these could be factors that should be considered. Another possible justifying circumstance is the fulfillment of duty. For all you know, the person is just doing his role or task. There could also be mitigating factors such as long service to the company or clean record for the past several years prior to this specific concern. Or there might be exempting circumstances or factors such as when management itself failed to inform the employee. So these are factors or circumstances that might be considered by the investigation committee, and this can serve to lessen the sanctions. On the other hand, there might be aggravating circumstances or factors that could lead to a higher sanction. Recidivism, or if this is not the first time that the person has committed such an offense and he keeps on repeating the action or inaction, then this could be aggravating factors. Use of threat or weapon is also an aggravating factor. There are also qualifying factors that the investigation committee can consider, such as evident premeditation when the case involves murder or death of a co-worker, and treachery or even cruelty can serve as qualifying factors or circumstances. And number 10, do not be afraid to let go of a problem employee. So long as you have conducted due process and you have tried to do some interventions, coaching to correct the person, and still there is no change in the behavior or the attitude or change in the performance, then you have to decide to let go of that employee. Who knows if letting go of that person might even prove to be good for that person and not just to the company. And you also have to protect the other employees. Rotten tomatoes would affect the clean and fresh ones. Take note that the right to choose employees is part of management prerogative. And so long as you have observed due process, you have accorded the person the right to due process, then letting go of that person who does not fit into the company is always a justified action. At this point, I would like to share something very technical to our HR professionals and managers, and this involves about the just and authorized causes for termination of employees. This is enshrined in the Labor Code of the Philippines. Article 297, previously Article 282 of the Labor Code, identifies the just causes for termination of employees. This could be gross negligence, gross incompetence, serious misconduct, willful disobedience, breach of company rules, or commission of crimes. On the other hand, Article 298, previously Article 283 of the Labor Code, when you say authorized causes, this does not mean that the employee has done something wrong, but there are circumstances that are happening within the company or as experienced by the company that would require the company management to let go of specific employees, such as installation of saving device, redundancy, retrenchment, and closure of the company. Article 299, or previously Article 284 of the Labor Code, identifies health reason as another factor for letting go of a certain employee. This is the case when that employee is suffering from a health condition that cannot be corrected or cured within the next 6 months, and continued work would expose that very person to risk or danger to himself or herself. And also, if the person is suffering from a communicable disease that might affect or endanger other co-workers. We have to take note that for just causes, the HR manager or professional has to observe due process. And this involves, as we earlier discussed, the twin notice rule. Without such, then the dismissal or termination of the employee is illegal or unlawful. For authorized causes, a 30-day notice is required to be accorded to the concerned employees, and HR managers or professionals have to notify the Department of Labor and Employment about such termination due to authorized causes. And while termination for just causes might lead to the forfeiture of certain benefits, under authorized causes, employees who are terminated shall be entitled to separation pay. The computation of separation pay for separated employees under authorized causes shall depend on the specified reason of the management. It could be 1 month or half month for every year of service, whichever is higher. If the reason is for retrenchment due to the desire of the company to prevent financial losses. On the other hand, if the reason is redundancy, then the employee is entitled to 1 month for every year of service. Now take note that even if there is a just or authorized cause, if the company did not observe due process, then the management or company will be liable to pay damages. If there is just cause and the company failed to observe due process, the company under the Agabon case will be liable to pay 30,000 for nominal damages. On the other hand, under authorized cause, if due process was not observed, under the JACA case, the management will be liable to pay 50,000 for nominal damages to the employee. Of course, if there was no just nor authorized cause, then it is a case of illegal dismissal. And in such a labor case, management should expect that the court will decide in favor of the employee, and such employee will be reinstated with back wages. Of course, if there is already a strained relation between the employer and the employee and reinstatement is untenable, then separation pay will be provided to the employee, and he or she will also be entitled to back wages. Implementing employee discipline in the company is a big challenge and task, on the part of HR managers and professionals who are expected to be the heart and soul of the company. But the reason why we have to implement employee discipline are the following. Number one, for deterrence. If you implement the rules and the sanctions and employees are disciplined, then it will serve as a deterrent to problem employees, and they will realize that they should follow company rules. They should stay within the guidelines of the company in terms of conduct and behavior. And anyone who is about to violate company rules would know that the sword of Damocles would fall upon his head. Second is for rehabilitation. It will be for the good of the employee for sanctions or employee discipline to be implemented so that he or she will have a chance to correct himself, and he or she will have a chance to go back to the fold of the company and assume normal or the expected behavior. Number three is for restoration. With the sanction and employee discipline imposed, it is expected that the original status quo will return and the work conditions will go back to the way it was or the way things were prior to the violation committed by the employee. Number four, of course, is for retribution. If the violation affected other employees, then the sanction or the employee discipline imposed will result to retribution, and justice will be served to those who were negatively or adversely affected. In closing, I would like to quote Zig Ziglar. Attitude, not aptitude, will determine one's altitude. So there you have it, ladies and gentlemen. We again had a very fruitful, productive HR session today. And if you want to continue receiving a copy of my videos and my presentation, please subscribe to my YouTube channel, click down below, and follow me on Facebook. Once again, thank you and have a wonderful day.